My brother was already halfway across the parking lot when I stepped out of the title company's glass doors, the signed document still warm from the notary's stamp in my hand. He had his arm around his wife's shoulder and she was laughing at something he said, the kind of laugh that comes out when you've just gotten exactly what you wanted. I watched them from the entrance, the afternoon sun flat and white against the asphalt, and I felt something settle in my chest, not relief, more like the stillness that comes right before you press send on an email you've been drafting for 3 months. His phone rang before they reached their car. I saw him fish it out of his jacket pocket without breaking stride, the casual confidence of someone expecting a congratulatory call. What he got instead stopped him mid-step. His wife turned to look at his face, and whatever she saw there made her stop laughing. The attorney's voice was loud enough that I could hear it from 30 feet away in that empty parking lot. She already signed. Tell me she didn't already sign. I didn't walk over. I didn't need to. I got in my car, adjusted the mirror, and pulled out onto the street. By the time I reached the first light, my phone was showing 3 missed calls from my brother's number. I let them go to voicemail. I should explain how I ended up in that parking lot because the moment doesn't make sense without the 18 months that came before it. My mother's diagnosis arrived the week after my 31st birthday. I had flown home to Tucson for the weekend, which is something I did less often than I should have, and we were sitting at the kitchen table after dinner when she told me, pancreatic cancer, caught late the way it almost always is. Her oncologist had used phrases like treatment-resistant and quality-of-life management, which is the medical system's way of telling you to stop looking for a cure and start making arrangements. I stayed. That's the short version. I sublet my apartment in Portland, put my things in a storage unit, and moved back into my childhood bedroom with its old painted furniture and the window that faced the backyard. I am a certified public accountant with a specialty in forensic accounting. I spent my professional life finding the numbers that other people tried to hide, reconstructing financial trails that had been deliberately obscured, building documentation that held up under legal scrutiny. It is not glamorous work. It requires a tolerance for detail and a willingness to be patient, and an understanding that the truth is almost always somewhere in the paperwork, if you're willing to read all of it. That skill set turned out to be more useful than I expected during the 14 months I cared for my mother. My brother, who is 6 years older than me and sells commercial real estate in Scottsdale, visited on an irregular schedule that seemed to correlate with long weekends and holidays. He brought his wife most of the time, a woman with very specific ideas about hospital-grade air filtration and the particular hazards of scented candles near oxygen equipment. His contribution to my mother's care was primarily logistical commentary. He had strong opinions about which home health agency we should use, and equally strong opinions about the invoices those agencies generated. He would stand in the kitchen going through the billing statements with the expression of a man personally victimized by the cost of professional caregiving. "We can't keep hemorrhaging money like this," he said once in October while I was updating the medication log on the whiteboard by the refrigerator. He said we the way people do when they mean you. Neither he nor his wife ever offered to cover a single expense. I didn't ask them to. What I did not anticipate was that by not asking, I was apparently communicating something, a willingness, an agreement, a precedent that would later be used as evidence. My mother died on a Thursday in early March. The hospice nurse had been there, and I had been there, and my brother had driven up the previous evening, which I was grateful for. The practical arrangements after a death are a strange kind of work. Detailed and administrative in a way that keeps your hands busy while your mind does something else entirely. I managed most of it. I had been managing most of everything for over a year, so it felt continuous rather than new. The conversation about the estate began 11 days after the funeral. My brother called on a Sunday evening and asked if he could come by the house to discuss some things he'd been looking into with his attorney. He said it in a tone of measured concern, the kind of tone you use when you're about to deliver news rather than ask a question. I said yes. He arrived the following Tuesday with a folder that his wife carried in from the car. Inside the folder were property tax records, or documents designed to look like property tax records. There were printed assessments, highlighted figures, columns of numbers in red. My brother explained, with what appeared to be genuine reluctance, that my mother's estate was carrying a significant tax liability. The house, a small rental property in Marana, and a portion of her investment accounts were all, he said, encumbered by unpaid obligations. He and his wife had spoken with their estate attorney and had determined that the most practical solution, the one that protected the family from further exposure, was for me to sign a deed of disclaimer on my share of the estate. He would absorb the liabilities himself. He framed this as a sacrifice. I asked several questions. He had answers for all of them. His wife added details at appropriate moments. The attorney, a man named Mr. Favre, who had apparently been the one to discover this situation and who had drafted the disclaimer documents, was available to meet with us later that week to walk through the paperwork. I said I needed time to think about it. My brother said there wasn't much time. The county assessor's office had a window. Creditors moved quickly once an estate entered probate. He used the phrase exposure for the whole family 3 times in 40 minutes. His wife touched my hand once and said she knew this was a lot to process on top of everything else, which I thought was a masterful sentence. After they left, I sat at the kitchen table for a long time. Then I went to my mother's filing cabinet in the bedroom, the one with the key she kept in the top drawer of her nightstand, and I spent 4 hours going through every document she had ever kept. What you need to understand about my mother is that she was organized in the specific way of someone who had grown up without money and spent her adult life making sure she knew exactly where all of hers was. She had a folder labeled TAX for every year going back to 2003. She had her property assessments filed by year with the county notices clipped to the front. She had a small spiral notebook in which she had recorded every significant financial transaction for the past decade, in blue ballpoint pen in her handwriting. The figures in my brother's folder did not match anything in my mother's cabinet. The assessed values were wrong, not slightly wrong, materially wrong, in the direction that would have made the liabilities look larger and the estate look less valuable. The tax period cited in the lien documentation corresponded to a year in which my mother had, according to her own records and the county's online portal, paid her property taxes in full and on time. I spent the next morning on the Pima County Assessor's website confirming what I already suspected. I called my colleague Sandra the following afternoon. Sandra had spent 12 years as a title examiner for a real estate firm in Phoenix before going independent, and she had the specific kind of knowledge that comes from spending over a decade untangling clouded titles and contested property records. I drove to her office in Tempe with the folder and my mother's files and a coffee I didn't finish. Sandra identified 4 separate discrepancies before we'd been through half the documents. "This lien doesn't exist," she said, setting one page aside. "I can pull the county records right now and show you." She did. It didn't. I drove home on the 10 with the windows down and thought carefully about what I was going to do next. I have a digital voice recorder that I have used for client interviews for years. It is a small flat device, matte black, unremarkable, the kind of thing that disappears in the interior pocket of a bag. I tested it that evening in my car in the driveway, running it through 2 full recording cycles and checking the audio quality on my laptop before I went inside. Then I called my brother and told him I was ready to move forward with meeting the attorney. He said he was glad I'd come around. We met at Mr. Favre's office in North Scottsdale the following week, a Wednesday, mid-morning, the kind of appointment that had been scheduled at their convenience rather than mine. The office had the particular aesthetic of a firm that wanted to appear more established than it was. The conference room had framed certificates and a view of a parking structure. My brother and his wife were already seated when I arrived. Mr. Favre shook my hand and spoke with the measured authority of a man who had rehearsed this conversation. The disclaimer documents were on the table. There was a pen. I performed uncertainty beautifully. I had been performing competence so long that its inverse came naturally. I asked Mr. Favre whether the liabilities he described were verified through the county. My brother answered before Mr. Favre could. I asked whether refusing to sign would mean I became solely responsible for the full tax debt. My brother's wife answered that one. I asked a question about the rental property specifically that I already knew the answer to, and my brother supplied every fabricated detail in a single clear paragraph, loudly enough for the table and the recorder in my bag to capture without any ambiguity at all. Then I picked up the pen and signed each page. The satisfaction on their faces was something I had expected and something I had prepared myself to witness without reacting to. My brother relaxed his shoulders in a way I hadn't seen all morning. His wife uncapped the water bottle she'd been holding since we sat down. In the hallway outside Mr. Favre's conference room, I had approximately 5 minutes while my brother completed some separate paperwork. I used those 5 minutes to upload the audio file through my phone to the Arizona Attorney General's Elder Financial Abuse Reporting Portal, to email a copy to the state bar's intake address, and to forward the original recordings along with Sandra's written analysis of the documentation discrepancies to the probate attorney my mother had originally retained to draft her estate plan, a woman named Ms. Okafor, who had been practicing estate law in Tucson for 22 years and who had, as it turned out, been waiting for someone to give her a reason to look more carefully at the disclaimer paperwork that had arrived in her office 3 weeks earlier without her involvement. What I had not told my brother, or Mr. Favre, or his wife, was that Miss Okafor had already filed a motion to delay the disclaimer's effective date pending her review of the estate documents. What I had also not told them was what I had found in my mother's original trust. My mother had worked with Miss Okafor 17 years earlier to establish a revocable living trust that, upon her death, became irrevocable, buried in the trust's terms in the section governing beneficiary conduct, the kind of section that most people skip because it reads like standard boilerplate, was a provision that Ms. Okafor had drafted specifically at my mother's request. Any beneficiary who obtained a written disclaimer or waiver from another beneficiary through misrepresentation of material financial facts would forfeit their own distributional interest entirely. The provision also included any attorney who assisted in preparing documentation used to effect such a transfer, which was a detail Ms. Okafor had added because she had seen this exact situation before and believed in building fences before things fell off the edge. The clause had never been triggered in 17 years. My brother's call came while I was still in the parking lot before I reached my car. I watched him take it from across the lot. I watched him stop walking. I watched his wife turn to look at his face, and I watched her expression change in the specific way of someone who has just understood that the ground beneath a celebration is not as solid as it looked. I did not wait around. I got in my car, turned on the radio, and drove back to Tucson on the 10. The probate court's ruling came down 9 weeks later. The disclaimer was voided on the grounds that it had been obtained through documented misrepresentation of material financial facts. My brother's interest in the estate was forfeited under the trust's own terms. Mr. Favre's conduct was referred to the State Bar of Arizona's disciplinary committee, and Ms. Okafor filed a separate civil complaint on behalf of the estate that I will not detail here because it is still working its way through the system, but the trajectory is not favorable for him. I want to be careful about how I describe what I felt when the ruling came through. It was not triumph. I want to be precise about that because the story is easy to read as a revenge story, and I don't think that's what it actually is. What I felt was something closer to the particular exhaustion that follows a long period of sustained concentration, the kind of tired that isn't unpleasant exactly, but that requires a significant amount of sleep and several weeks of not making important decisions. I used a portion of the estate to pay off the credit card balance I had accumulated during my mother's illness, which was not a small balance. I set aside a portion for the expenses I had paid directly for her care over 14 months that I had never asked anyone to reimburse, because I had not anticipated needing to ask. I donated a piece of my mother's jewelry to the hospice organization whose nurses had been present at the end. I started the process of finding a smaller place in Tucson, something I could afford without the financial pressure that had been sitting in the back of my mind since I sublet my Portland apartment. I have not spoken to my brother since the ruling. I don't expect to. I deleted his contact from my phone. Not out of anger, but because keeping it there was a kind of open loop that I didn't have the energy to maintain. His wife, I unfollowed on everything quietly and without ceremony. I had 2 sessions with a counselor who specialized in grief and family estrangement, and she said something that I have returned to several times since. She said that the people who care for the dying are often the people who loved the most, and that love, when it goes unacknowledged and unreciprocated, tends to curdle into something else if you don't catch it in time. She said I had caught it in time. I found that useful in the way that accurate things are useful even when they're not comfortable. What I keep thinking about is this. I was in my mother's house for 14 months. I tracked her medications, I updated the whiteboard every morning, I won 2 insurance appeals and lost one. I held her hand at the end. None of that was done in expectation of compensation. I would have done it regardless of what was in the trust. That is the actual truth. And I know it is the actual truth because I felt nothing but stillness when I signed those disclaimer papers. Not because I had surrendered anything, but because I had already made my peace with the possibility of walking away with nothing. And it was that peace that made everything else possible. My brother needed me to be desperate. He had constructed the entire architecture of the scheme on the assumption that I would be too exhausted and too grieving and too financially pressured to read the documents carefully. He had, in other words, mistaken the person who does the detail work for someone who doesn't understand it. That is the part I think about most. Not the outcome, not the ruling or the forfeiture or Mr. Favre's referral to the disciplinary committee, but the specific miscalculation, the assumption that the person who carried the weight was also the person who could be made to carry the loss. The assumption that caregiving and competence don't exist in the same body. My mother's trust had a provision in it because she had seen something in people over a long life. Something about the way money moves through families after a death. The way grief can be weaponized by the people who showed up least when it was inconvenient. She had asked Miss Nuss, Okafor, to build a fence. I think about her sometimes, sitting across from Ms. Okafor in that office 17 years ago, asking for that clause with a specificity that suggests she had already thought through exactly what kind of trouble was possible and who was likely to cause it. My mother was organized in the way of someone who knew things would eventually need to hold up. They held up. I want to ask you something before I go, and I mean it as an honest question, not a tidy closing flourish. If you had spent over a year doing everything, the documentation, the appeals, the medications, the 3 a.m. phone calls, and the people who had done almost none of it arrived with a folder and a pen and a practiced expression of reluctant generosity, how long would it take you to realize what was actually happening? And once you realized it, what would you be willing to do to make sure the record reflected the truth? I keep coming back to the folder, not what was in it. I've gone through those numbers enough times that I could recite the fabricated figures from memory. But the physical act of my brother carrying it into my mother's house 11 days after we buried her, the folder was neat, tabbed. The highlights were in the same shade of red throughout, which means someone had sat down and prepared it carefully, probably days before my mother died, possibly longer. That's the part that stays with me. The preparation. The patience. The decision, made at some point while she was still alive, that this was the plan. I don't say that to assign blame in a way that feels satisfying. I say it because I think it's important to be honest about what actually happened, and what actually happened is that I almost missed it. If I had been less familiar with property records, or more exhausted, or simply less willing to spend 4 hours in a dead woman's filing cabinet on a Sunday night, the disclaimer would have held. That version of events was entirely possible. My brother had counted on it. What stopped it wasn't luck. It was the specific combination of 3 things that I've been turning over ever since. The first was that I had spent my career building the habit of checking. Not because I suspected everyone, but because I had learned that numbers don't lie on their own. People arrange them to lie, and the only way to catch the arrangement is to compare it against something that can't be altered. My mother's spiral notebook couldn't be altered. The county assessor's online portal couldn't be altered. When I put my brother's folder next to those two things, the discrepancy was visible inside of an hour. That habit, the quiet, unglamorous discipline of verifying rather than assuming, is what made everything else possible. Intelligence without that habit is just confidence. And confidence without verification is a very expensive thing to carry into a negotiation. The second was that I called Sandra. I want to be clear about this because I think people underestimate it. I didn't sit alone with the information and decide I was right. I drove to Tempe with the folder and my mother's records and sat across from someone who knew more than I did about the specific thing I was looking at, and I let her tell me what she saw. There is a kind of integrity in that, in being willing to have your suspicion confirmed or corrected by someone whose expertise you genuinely respect. Ego would have kept me home. Sandra found 4 discrepancies I had missed. The third thing is harder to name, but I think it's the most important. I was willing to sit with the discomfort of what I was about to do. Signing those papers was not a small thing. Walking into that conference room and performing uncertainty while my brother and his wife confirmed every fabrication on the record, that required a steadiness I had to work to maintain. There was a moment, pen in hand, where the easier thing would have been to stop, to make a scene, to confront them right there. I didn't, because I understood that the record mattered more than the moment, and that patience in that room would produce a result that no amount of confrontation could have matched. My mother built a fence into her trust because she understood something about the way families work under pressure, that grief is a resource that some people will use, and that the only protection against that is documentation that can speak when you can't. She was right. And I think about her in that attorney's office 17 years ago, asking for that clause with the calm of someone who had already thought carefully about who in her family might someday need it. She knew. She prepared. She trusted that the person who would need that fence would be the same person who would think to look for it. I'd like to think she was right about that too.